Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs and rules that matter to you. I'm your host, Kriti Mishra, and today the spotlight is on the amended IT rules. What does it mean for the internet platforms and users in India? That and much more. But before the detailed analysis, let's take a look at the highlights. Earlier, the intermediaries were only required to inform users about not uploading certain categories of harmful or unlawful content. These amendments impose a legal obligation on them to take reasonable efforts to prevent users from uploading such content. For effective communication of the rules and regulations, it is important that the communication is done in regional Indian languages as well. Grievance appellate committees will be established to allow users to appeal against the inaction or decisions taken by the social media platforms on user complaints. However, users will always have the right to approach courts for any remedy. So why were the rules amended? Well, the rules have been modified against the backdrop of complaints regarding the action or inaction on the part of the intermediaries on user grievances regarding objectionable content or suspension of their accounts. Under the amended IT rules, a social media company referred to as intermediary must ensure that users do not post or share any information that does not belong to them. The IT rules also put the onus on the intermediary to ensure content posted on the platform is not obscene, pornographic, invasive of others' privacy, hate speech, promoting illegal activities, or threatening the unity, integrity, defense, security, or sovereignty of India. And for deeper understanding of the amended rules, I'm joined by a very special guest in the studio. Joining us, Mr. Rajeev Chandrasekhar, Minister of State for Electronics and Information Technology of India and Skill Development. So, welcome to Sansad TV and thank you so much for joining us. We also have young and bright students in the studio with us. Of course, they're going to pose questions, but let's begin the discussion by talking about the amended rules. Now, I've seen that you've said that internet space is and should be open, accessible, transparent, and trusted for all. What will change for the social media users? How will the dynamics change?
So thank you for arranging this interaction and thank you for inviting me to speak here today. I first want to set up a context that the internet today is becoming more and more ubiquitous and it is becoming more and more part of our daily lives. And I happen to be one of those people who worked on the internet in the early days in the 80s. And internet was always seen as a force of good. Yeah. Connect people, allow people to interact, allow people to communicate with each other. But it is also clear in the last 4 or 5 years that the internet is also becoming a place where harm and criminality abounds. So as a government, we have created essentially 3 boundary conditions around which we do policy making. And we consider it as our duty to the citizens of India because we are going to have 120 crore Indian citizens online. Yes. We have already 84 crore Indians online. Women, men, elderly, students, youngsters, all of them using the internet. So the boundary conditions are that the internet should always be open, i.e. not controlled by anybody. B, that the internet should always be safe and trusted space for everybody who uses the internet. And the third boundary condition or the guiding principle is that the internet should always be accountable to the digital Nagrik, the actual Nagrik who uses it. The platform should always have an accountability relationship. It is in that context that we build these IT rules. The IT rules were first brought out or notified in May 2021, and they brought the concept of accountability to the fore. Between May 2021 and today, we have noticed that there are a number of lacunas in the way platforms respond to those obligations and to make the internet a safe and trusted place. So these amended rules are a way forward in what will always be an evolving jurisprudence, evolving nature of rules and laws to make sure that the internet is a safe and trusted place, an accountable cyberspace for all digital Nagriks who use the internet.
But sir, as you mentioned about the figures, let's look at the enormity of the situation. 84 crore users, could be 120 crore very soon.
Correct.
Are we well equipped to handle that kind of a situation?
No, so this is a discussion which is a little bit of an academic discussion because are we well equipped? Were we well equipped? Were governments and citizens ahead of the platforms in terms of the rules and do's and don'ts? And the answer is probably not. We were not. For a long time, internet platforms, which we refer to as intermediaries, were protected explicitly by Section 79 of the IT.Act from any prosecution and, in a sense, from any accountability. In the US, there is a similar provision called Section 230. So in a lot of ways, the platforms were always seen as simply carrying somebody else's content and therefore not being accountable for the kind of content that was carried on the platform. So we are today making an effort because our Prime Minister has laid out a goal of $1 trillion digital economy. Increasingly, government and citizens engage via the internet. And the internet, like I said, 120 crore Indians will shortly be on the internet, making India the largest connected country in the world. So it is very, very important that the internet is a safe and trusted place. And that the relationship between a citizen and a platform, whether the platform is a big platform or a small, foreign platform or an Indian platform, has an element of accountability. And so these rules are meant to deliver on that.
Let me play devil's advocate here, Mr. Chandrasekhar. Now, social media companies will have to follow the rules.
Correct.
The government also says that they have to uphold the constitutional rights of the users as well.
Correct.
Now, as a social media platform, it is easier for me to follow the amended rules and stifle the free speech or liberty or constitutional rights of the citizens?
So here's the thing. I think it is, and there has been an attempt to paint the relationship between government and social media intermediaries or intermediaries in general as adversarial.
That's true.
And I have made it my mission, in a sense, to say that this is not an adversarial relationship because platforms and the government and the citizens have a common objective that they should be able to access the internet freely. They should be able to use the internet without worry and fear. That means safety and trust is important. And when there is a relationship between a user and a platform, the platform is always accountable to the user for any grievance that the user may have. In my opinion, this is a partnership because it is a win-win. The Nagriks win, the citizens win. The platforms benefit from the internet being devoid of harm and criminality. And the government keeps the internet as a safe and trusted space because that is where the digital economy innovation is growing. Now to the issue of free speech. There is nothing in the IT rules or the IT.Act that impinges on free speech. What it does is, and actually specifically in the IT rules say, Article 14, 19 and 21 can never be contravened by any platform.
Okay.
Regardless of the platform is a San Francisco-based platform or a New York-based platform.
Right.
The constitutional rights granted to every Indian citizen by our constitution, for which the government is a trustee, no platform can arbitrarily violate or violate in any event. Number one. Number two, the exceptions that we have carved out under 3(1)(b), 1 to 9, are exceptions that fall under the category of 19(2). Understand that right to free speech in India is a fundamental right, not an absolute right. And 19(2) carves out the exceptions to the right to free speech. That means you cannot say things that are insightful.
Right.
You cannot create public order problems. You cannot do things against national interests. So you cannot do pornography. You cannot use somebody else's content. So the stipulations from 1 to 9 are nothing to do with free speech. They are essentially saying user harm and are completely consistent with 19(2) of the Constitution.
Right, sir, but we understand that there's going to be a grievance appellate committee.
Yes.
And before I take the questions from our audience here, I'd like to understand, how will you ensure that there's compliance from the social media users? What are going to be the punitive actions?
So here is the thing, one of the things that we found when the May 2021 rules were enacted, we said that all platforms must have a grievance officer.
Yes.
And our idea was that you appoint a grievance officer and therefore if there is a citizen who has a grievance, the grievance officer will address that. But that has not happened. So a lot of people have appointed naam ke vaste grievance officers. Grievance aate rahe and you get a bland response back if you get a response back that aapka grievance has been received and noted. We have made it very clear that that is not acceptable. We have to have a foolproof mechanism where every one of those 120 crore Indian citizens, if he or she has a grievance, the platform is duty bound to address it. And I have indicated during consultations that the appellate committee is a way to disincentivize platforms from not doing their job.
Right.
If they were doing their job and they were addressing all the grievances, तो appeal there's no question of an appeal.
Bilkul. True.
So we have said this, and then there was a question about, oh no, government is going to run the appellate committee.
Yeah.
And I said to them, look, if you as an industry and you as intermediaries can come up with a self-regulatory organization run by you, and that you come to a consensus, I'm willing to accept that. I waited 3 months, and they did not. So I can't wait indefinitely. Our government cannot wait indefinitely, and our Prime Minister is very clear. Citizens' rights are very important. Ease of living for our citizens are very important. And therefore, we put in a GAC today, which has 1 government member and 2 outside members. Even today, I have said to the industry that if you come with a working model of a self-regulatory organization that can handle the appellate jurisdiction of this, we are more than happy to incorporate that, because the government is not really terribly thrilled to deal with crores and lakhs of grievances
I'm sure.
On the internet. So, ये हमारा कोई काम नहीं है. This is not our full-time job.
Let's open the floor to our audience here. Please go ahead, introduce yourself and speak your mind.
Like trolling and social media cases are rising day by day. So highlight the steps taken by the government to stop.
So I think you raise an important point, and we call it a broader issue of user harm. And so a lot of the concept of safety and trust that I spoke about, the rules go to a large extent in dealing with safety and trust on 9 issues. But there are several issues that we cannot deal with in the rules, for which we are going to create a new legislation by early 2023, which deals with exactly this. Trolling, cyberbullying, doxing, gaslighting, all of these issues that make the internet a terribly frightful place for a lot of people to operate in. We have seen, for example, during online gaming, I was conducting a consultation recently, and the conventional ways to encourage, have a discussion between government on the online gaming companies. We called online gamers to have a chat with us. And it was very clear from the 1 or 2 girl gamers, that online gaming is a very, very hostile
That's true.
place for women gamers. So therefore, we take this issue of user harm and the corollary of that, making the internet a safe and trusted place, very seriously. ये rules आ गए हैं अभी, लेकिन we will create a brand new legislation to replace the IT.Act, where the IT.Act does not have enough powers to deal with these kind of issues, because it's a 22-year-old
That's
act.
right.
And these are all more recent phenomenon. But absolutely, to the lady's point, that we consider it our mission in the government, our duty. Our Prime Minister has said this repeatedly, that the internet is a place where 120 crore Indians should fearlessly, without fear of doxing, without fear of trolling, without the fear of identity theft, all of that, be able to conduct whatever they do on the internet, education, working, shopping, whatever, should be. Therefore, the internet will be a safe and trusted place. And you, like I say in English, please stay tuned. By 2023, you will have an act and a law that this country deserves, and all of you deserve. It will be called the Digital India.Act.
So as a parliamentary channel, I just got my headline there as far as this new legislation is concerned.
Absolutely.
Let's go ahead and take another question.
If my parents are receiving some inappropriate messages and they don't know because of their innocence and they shares that message, will they be punished for that?
Sunny, look, under the IT rules, there is a provision called first originator. Now, let's assume for a minute you get a message. And you get a message which is inciting religious hatred or, inciting public order, and you innocently forward it. At some point, when the police detect it and file an FIR against that, the intermediaries are obliged to say who originated it. आप third level में, fourth level में, आप उस tree में, if you have caught in the fourth level, that is not what the government or the law enforcement agency is interested in. So therefore, in the rules, there is specifically a provision that the platforms have to detect and identify and report the first originator, and that too only in the event of a crime.
Let's take another question.
Does new IT rules restrict our freedom of speech? Sir, recently in September 2022, sir, 45 videos from YouTube were removed. Sir, in matter, sir, because those videos were stating facts about Agnipat and all.
As a matter of fact, in the IT rules, there is a provision that says that the constitutional rights of all our Indian citizens can never be infringed on. We as a government, we are trustees of the constitutional rights of citizens. We protect them. However, I want to, in the context of free speech, explain to you, because you're all students, that free speech in India is not an absolute right, it is a fundamental right. And it is subject under Article 19 to restrictions, reasonable restrictions. Reasonable restrictions are you cannot say things in the name of free speech that then incite public order. You cannot say things in the name of free speech that is misinformation and false. You cannot say things in the name of free speech and then incite and create national security issues. So this generalization ki YouTube mein we have taken down posts because they said something about Agnipath is wrong. It would have either said something absolutely false about Agnipath or it would have incited some people to go after it. This government will never take down and has, by the way, even if it does take down, all of you have the right to go to court and challenge the takedown.
Time for another question. Please go ahead.
Good afternoon, sir. My question to you is, can you please elaborate on the relationship between GAC and the digital intermediaries with respect to decision making?
No, so here is the thing. I'll make it very simple for you. Let's say you are a consumer of a platform and you find something that is you're dissatisfied with. Under the May 2021 rules, you are supposed to send an email to a grievance officer that they have appointed. And the grievance officer, in a limited amount of time, is supposed to respond to that grievance and address that. Now, what has happened, unfortunately, is that large number of platforms are not doing that. So this leads to a situation, and what do you do to grievances that are unaddressed? So the GAC is a body that will, and it will not be a body as in a building or a group of people. It will be a digital platform. So let us say you are the consumer, and I'm using your example again. You will go to that platform. You will say, this is my name, this is my grievance, this is the platform. The people behind that, and there will be a 3-member group, and there will be multiple 3-member groups who will then reach out to the platform, get their answer, and if they find that the platform has erred, then they will rule against the platform. If they find that your grievance is not justified, they'll rule against you. For example, I'll give you an example. If you say, मैंने गलती से कुछ कह दिया और आपके platform में you have put my speech, I want it removed. That is not something they are obliged to do. You've made a mistake, you have made a mistake. So the GAC will tell you, no, I'm sorry, your complaint against the platform is not justified. Conversely, if it is, for example, yesterday I had an example of a singer who's built a song, and it is his song, his creativity. But somebody else has posted something with that song without taking his permission or giving him any rights or any license fee. तो उसका अपील अगर जाता है GAC में, तो GAC will tell that platform, वो तो take it down and tell that particular person to compensate him.
In recent years, especially after the Shreya Singhal case versus Union of India in 2015, and the section 66A was struck down of IT.Act. And even in contemplate to this striking down of this section, after 7 years, like in 2022 and 2021, more or less, another grievances committee they are seeking to form. Why there is so much of ambiguity between the striking down of an Shreya Singhal case, 66A section, and forming of this committee?
Sir had a huge role to play there.
Yeah, so I am a petitioner in that case. Shreya Singhal was the first one who filed the case, but bulk of the arguing of that case, me and my lawyers did.
Yes.
So I am on your side. I believe privacy was a fundamental right, and Supreme Court struck down 66A. Sorry, that is 66A, not privacy is a fundamental right. Now, 66A has been deemed to be unconstitutional by the Supreme Court, and that is the position in law. It has not been specifically repealed because it is part of the IT.Act. The IT.Act is a 22-year-old act. It was first passed by Parliament in 2000. And the act is still on the statute books. A part of the act was deemed to be unconstitutional by the Supreme Court, which is section 66A.
Yes.
So therefore, if any police person today files a case against Section 66A without understanding that it has been deemed to be unconstitutional, any court will strike it down because it is unconstitutional. And if you are you a law student?
Yes, sir, I'm a law.
So if you buy the IT Act, you will find under Section 66A there will be a description saying it has been found to be unconstitutional by the Supreme Court. That is a separate issue. The Grievance Appellate Committee is under the IT Act, the intermediary guidelines and the intermediary rules that specify what are the do's and don'ts for the intermediaries. And the intermediaries have to deal with grievance officers, through grievance officers, the grievances of all the digital nagriks and consumers. जब वो नहीं करते हैं, नागरिक का हक बनता है कि वो अपील करे GAC में. Section 66A में और इसका कोई ताल्लुक नहीं है. There's no connection at all between the two issues.
My question to you is, we see a lot of bots coming up nowadays, especially on Instagram.
Right.
And we can see that most of them are either hackers or they're pornographic bots. And we can also see that these bots are especially targeting youngsters like us. So what are your views on the same?
No, look, I have said this when I was not a minister and I say it again today. Bots and algorithms are a dangerous combination. If we thought chaos was bad, but bots and algorithm bring a different level of chaos and targeting and user harm. It is a very important issue. It is an issue that we believe will be addressed in the new act, because currently the existing act has no provision to deal with this. It's a 22-year-old act, as I said. So we have a new legislation that talks about user harm and user safety and trust, which means any intermediary using bots and or algorithms will be subject to certain higher levels of scrutiny and accountability to the consumers that they serve.
Sir, as you stated that this compliance is a win-win for both the platforms as well as the citizens, then what is your stance on WhatsApp taking the government to the court for the same?
No, look, like I said, the greatness of our country is even when you're presented with the right thing, you have an ability to go to court and challenge it. WhatsApp has argued that the first originator requirement in the IT rules is an invasion of privacy. That is their argument. We have put our petition in the court, and I have argued strongly in person with them. And I know a little bit of technology, so it's very difficult for them to pull a fast one on me.
I'm sure.
So I said to them that this is nothing to do with privacy. It is a question of tagging, and it is a question of your ability to detect who commits crimes on your platform. Now, here is your students, and this is an important thing for you to understand. One of the things that platforms have done for many, many years is say, we want anonymity.
Yes.
Because anonymity is, in a sense, the protection of privacy. And recently in Parliament, there was a question where an MP stood up and said, why are you allowing anonymity and why don't we do KYC for all users of social media? And I said to them at that time, in Parliament, it's on record, that our government continues to believe in privacy. Our government continues to believe in the power of anonymity, because if a citizen chooses to be anonymous, he or she can choose to be anonymous. However, anonymity cannot be a way to camouflage crime.
Absolutely.
And user harm. So anonymity will not be allowed to be doing things that are illegal on the internet just because you are anonymous. So that is why first originator says, if you do something illegal, the platform should tell the LEOs, the law enforcement agencies, who's behind that that particular illegality.
Can social media platforms still deplatform users?
They can deplatform you, but after these IT rules, they can't deplatform you arbitrarily.
Right.
We have said Article 14, 19 and 21 cannot be violated by any platform who is serving an Indian citizen. The argument that a lot of these platforms, some of these platforms used in the past was, no, our guidelines, which are American guidelines, do not recognize the fundamental right. So if we wake up in the morning and think you should be deplatformed because you did something wrong, we don't have to give you the natural justice option and we can deplatform you without asking you for the reason. That cannot be done anymore.
Let's take another question.
So my question for you is, does new rules of IT ensures the privacy of the users?
नहीं, वो अलग है. उसका we are coming up with a new legislation called the Digital Personal Data Protection Law. You will soon see that it will be out for consultation.
So my question to you is like there's a particular time frame which is set for resolving the conflicts. So, however, there may be some conflicts which may require some more scrutinizing or more considerable time to get resolved. So why this particular time frame is set for resolving the conflicts?
Lady in the black shirt also.
Yeah. So, hello, sir. My question to you is the user can approach both the courts and the GAC to raise their complaints. So, don't you think this will lead to a confusion if the decisions are different?
You can't go to both simultaneously. I mean, let's say today you have a consumer affairs issue. You can't go to the consumer affairs tribunal and the court simultaneously.
Of course.
Yeni, you can choose. You can say, I will go to the GAC and I'll get that address there, or I'll go to the courts. The reason we have created the GAC, it's easier, it is cheaper, it is faster, it is digital. Courts are complex processes, and it is not easy for an individual to find his or her way through the court system. So that is why we made it an easier process, GAC, but have never said that you cannot go to the courts. You can always go to the courts. That is not a conflict. That is, and I want to explain this to you. Today, a platform is obliged to not have content on the platform from the 1 to 9. If you read 3.1b, is the rule 3.1b, there are 1 to 9 cases of content which they cannot have on the platform. That ranges from pornography, CSAM, which is child sexual explicit material, national security issues, religious incitement. There are 9 issues. If they are not able to pick up that content on their own, maybe there is the platform sometimes fails to see that content. But if you point it out to them, look, there is some objectionable content that violates 3.1b 1 to 9, then they are in 72 hours supposed to respond. They cannot do like this. So even if they do like this in the first round, the second round, 72 hours is the timeline by which they have to respond. That is the casted obligation on them if they want to remain intermediaries with the safe harbor protection of the Section 79. None of you have asked me this question, so let me tell you. When an intermediary does not comply with the rules, what happens? Nothing happens. Nobody gets sent to jail, none of that happens. All that means is that the Section 79 protection, safe harbor that an intermediary has from prosecution falls. So then they are liable for any or all content on their platform.
Right.
And so therefore, they are no longer enjoying the protection of Section 79. So it's a very fair construct that in India, if you want to enjoy protection under Section 79 as an intermediary, then you have to earn it by taking on the obligation of keeping the internet safe and trusted, social intermediary platform safe and trusted, and make it possible for people to work there without fear and worry about...
Right, sir. All right, sir. Thank you so much for joining us and giving us those important clarifications and taking all the unfiltered questions. Thank you so much. Well, viewers, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side.